I am thrilled, and it is such a pleasure and such an honor to have an opportunity to participate in this fireside chat of our 48th Solicitor General of the United States. And first, I want to thank you so much for being here and for joining us and participating in this.
Thanks, Amy. It's great to be here. And was just mentioned how Amy argued her first Supreme Court case this past term, and we were particularly grateful to her for doing that. In a small handful of cases, the United States declines to defend the position that the United States took in the court below. And this was one of those cases where we declined to defend a Social Security Administration position that had been taken in the court below. And when we do that, we always ask the court to appoint an amicus to represent that position so that the court has the benefit of both sides of the argument, even though we, the United States, are not presenting that side of the argument. And so we're always grateful when folks like Amy step forward and take on that position, and they're put in that position precisely because we have declined to defend the position that the United States had taken previously. She did a fantastic job. I was at the argument, and we were grateful to her for doing that.
Well, you were very kind after the argument and talking with me about it, so I appreciated that. First of all, let me just get this clear. You are General Francisco, right?
You know, I try to get my daughters to refer to me as that, but so far they haven't bitten. In court, I am referred to as General Francisco. That's about as far as it goes.
That's kind of heady stuff, right?
Yeah.
Right. Now, am I the only person who thinks you're Spanish?
You know, no. And if you look at my biography, one of the jobs I held early on in my career was as a young attorney in the White House counsel's office during the Bush administration, where I was hired by then White House counsel and subsequently Attorney General Alberto Gonzales. And to this day, I think that one of the reasons that Gonzales hired me is because he mistakenly took me for being Hispanic.
Francisco, but I looked at your Wikipedia page, so I found out no. So would you tell us a little bit about yourself? You can go back as far as you'd like.
Sure.
But starting maybe from where you feel comfortable, you went to college.
Well, I'll actually go back a little bit further than that. I grew up in a small town in upstate New York, right on the shores of Lake Ontario. My father came here from the Philippines. Strange place for a Filipino to decide to set up shop in upstate New York, one of the coldest, snowiest parts of the country, but that's where he went, and that's where he went with my mother, who was from Connecticut. And so I spent my formative years in Oswego, New York, before going off to college, first at Brandeis University for a year, and then to the University of Chicago, where I then went on to law school afterwards at the University of Chicago Law School. At the time, I was pretty sure I wanted to be a products liability litigator.
Oh.
So I was pretty intent on staying in Chicago, clerking for a district court judge, learning the trade of being a trial court litigator and pursuing that. But then I got called by a judge on the Fourth Circuit Court of Appeals named Michael Ludig, who is now the general counsel of Boeing, and asking me to come and clerk for him there. The interesting thing about Judge Ludig is that he was Justice Scalia's very first law clerk when Justice Scalia was on the DC Circuit. And so Justice Scalia had a pretty standard practice of always hiring one of Judge Ludig's 3 law clerks. I was very fortunate that when I arrived at Judge Ludig's chambers to start the clerkship, the other 2 clerks had already been hired by the Chief Justice and Justice O'Connor. And so Justice Scalia had no choice but to take me
as his
law clerk. I still at that point had some thoughts of going back to Chicago to be a products liability litigator, but I kind of got sucked into the Washington, D.C. machine. And so I joined up with a small Washington law firm there. They say that after 7 years, you're part of the problem. And so now I think I am deeply part of the problem.
Well, that Washington law firm that you worked with, it was really quite an experience for you. I mean, one of your first clients was the president?
So it was a fantastic little law firm called Cooper, Carvin, and Rosenthal. Now it's called Cooper and Kirk. was started by two lawyers who worked in the Reagan Justice Department, Chuck Cooper and Mike Carvin. And one of the early matters I had an opportunity to work on was the Florida recount litigation, where Mike Carvin went down to represent then Governor Bush in connection with the litigation that occurred afterwards. I was a very young associate at that time, and I was called down with Mike to help organize that little litigation. An interesting little known fact is that, I'll back up a little, I was the third associate that Cooper, Carvin, and Rosenthal had ever hired. The second associate that they had ever hired was a young man named Ted Cruz. At the time, Ted had left the firm to go work on the campaign, and he was the one that was tasked with pulling together the legal talent in Tallahassee to carry on the litigation on behalf of then Governor Bush. Ted was a good friend of mine at that point, and so when he reached out to us, I went down along with Mike Carvin and a woman named Rachel Brand, who you may recall was the Associate Attorney General for about a year at the beginning of this administration before heading off to Walmart as their Chief Legal Officer.
So how was that experience? What did
it was an unbelievable learning experience for a young lawyer. Every day you were either on a complete high or a complete low. You thought that everything was over. You thought that there was a sliver of hope. One of the real skills I learned was how to write briefs of amazing consequence in 8 hours, because that's essentially what we had. A brief would be filed at 9 a.m. in the morning. We'd have until 5 p.m. to file our response. It would then be argued at around 7 or 8 o'clock that evening and decided thereafter. So now when I get matters on my desk with a very short turnaround, I always think that's not that short of a turnaround.
No big deal.
We got plenty of time.
Been there, done that.
Yeah.
So that must have been really a huge experience. You were so young to be involved in that kind of...
It was an amazing experience. I remember several nights where we were on the downturn and we thought things were, that we were not going to prevail, and sitting around with other young lawyers trying to figure out what are we going to do. And then when we were on the upswing and it looked like things were heading in our favor, a completely different conversation about what we were going to do.
And look how it turned out, right?
That's exactly right. My first job in government, other than my clerkships, was after the Florida recount and after President Bush's inauguration, going and serving as an associate counsel in the White House counsel's office. At the time, there were 11 lawyers in the White House counsel's office. There was the White House counsel, Alberto Gonzalez, the deputy White House counsel, a man named Tim Flanagan, and then 9 associate White House counsels. And I think that every one of those lawyers, save for one of the associate White House counsels, was part of the litigation team handling the Florida recount litigation. It was the place where, not much different than this, was the place where we all came together and met each other, met a lot of other people who were involved in the campaign. I was not involved in the campaign. I've never really worked for a campaign, but when the litigation happened, I was involved in the post-election litigation, as were most of the others that were down there. So we all got to know each other. That group included now Justice Kavanaugh, who was one of the originals in the White House counsel's office. It was a great group of folks.
And then, so you were in the counsel's office, but then you had another job in government before you left, right?
Sure. So I served in the White House counsel's office for about 3 years, most of the first term, President Bush's first term. Then I went over to the Department of Justice in what's called the Office of Legal Counsel. OLC is the office within the Department of Justice that essentially states the definitive legal position of the United States on a whole range of issues. So anytime the president signs an executive order, OLC has to first approve it for form and legality. Whenever two agencies disagree on a legal position, OLC is the entity that resolves that disagreement. And by regulation, OLC's opinions are binding on the rest of the executive branch. So I was a deputy in the Office of Legal Counsel for about 2 years. So for during those 5 years, I was actually not doing any litigation. It was all kind of a in-house counsel type counseling position where you were advising others on what they could and couldn't do, but you weren't ever actually appearing in court.
How'd you like those two jobs? They're totally different offices, different. How would you compare them? Do you like one better than the other?
They're very different jobs. I can't say I like one better than the other, but they were very different. When you're in the White House counsel's office, you have tons of legal issues that are landing on your plate, but you never have more than an hour to digest it. So you're really only about an inch deep on any legal issue, and it is truly the intersection of law and politics. Law and politics and law and policy, because you're constantly advising policymakers and people that have a much more political focus on what they can and cannot do consistent with the law. And it was fascinating, fast-paced. You met lots of interesting people. I remember one time sitting in the White House mess, which is the dining room for the White House staff, and then Deputy Chief of Staff Josh Bolton came walking into the dining room with Bo Derek. So that was something.
That's pretty exciting. Right?
The other highlight was
typical people.
The other highlight was I was standing outside of Karl Rove's office, whose office was right next to Judge Gonzalez's, and he came walking out with Bono. So I got a chance to shake Bono's hand. Similarly with Bruce Willis, we had a big adoption event at the White House, and both of my girls are adopted. So we were at the adoption event with then my older daughter, because we hadn't yet adopted my younger daughter. Bruce Willis is a very big proponent of adoption. So he had come to participate in the event. And so I'm walking out of Judge Gonzalez's office carrying my then 2-year-old daughter, and Bruce Willis comes walking out. So we got a chance to meet Bruce Willis. So in that respect, the White House, I think, was much more fun and exciting. Office of Legal Counsel didn't have any of that excitement. It was much more bookish and nerdy, but you really did dive into legal issues in a way that you didn't do in the White House counsel's office. So from a professional perspective, I'd have to say OLC was more interesting, because you really did get into really interesting separation of powers, national security, foreign policy issues, and there, by the time you finished your analysis, you were a definitive expert in that area of law.
Well, that's so interesting. So when you left there, you must have wondered, how am I going to do something that thrilling? I'm young. What am I going to do now? So what did you?
I have to say, at every stage of my career, when I've moved to the next job, the previous job was so interesting, I always say, well, the next job is not going to be nearly as interesting, so I have to get used to having a more ordinary, less interesting job. And so when I moved to Jones Day after the Department of Justice, I said, all right, I'm going to have a standard commercial litigation practice. It'll be great. Won't be quite what I was doing before, but it'll be very interesting. Little did I know, though, that within that practice, we would develop what I now, looking back, find every bit as interesting as what I was doing in the government, and then more so. We ended up developing a practice that focused on litigation against the federal government. So some of the highlights of it were we represented a company called the Noel Canning Company, which is a Pepsi bottling facility based in Yakima, Washington, challenging President Obama's recess appointments to the National Labor Relations Board, and indirectly his appointment, Richard Cordray, to head the Consumer Financial Protection Bureau, because you may recall President Obama named those individuals through recess appointments rather than seeking Senate advice and consent. It's precisely the type of big separation of powers issue that I was handling in the Office of Legal Counsel, only now I was in private practice actually litigating the case in court.
That must have been so fun to be.
It was fascinating. And when it first happened, I remember when President Obama named the recess appointments to the National Labor Relations Board and Richard Cordray to the Consumer Financial Protection Bureau on the same day, everybody knew they were going to be challenged because everybody knew that this was the first time the president had tried to make a recess appointment during what's called a pro forma session. That's where the Senate gabbles in and out of session in really just a couple of minutes, the principal purpose of which is to prevent the president from making recess appointments. Up until then, presidents, although they were suspicious of what the Senate was doing, hadn't directly challenged it. So this was the first time that the president had actually stepped forward and challenged the notion that these pro forma sessions could prevent recess appointments. So we all knew it was going to be challenged. Cordray at the time was the much bigger fish as the head of the Consumer Financial Protection Bureau, a very new and somewhat controversial agency. So most of the litigators were focused on trying to figure out how to bring a suit to challenge Richard Cordray's appointment. But one of the things that we realized was that because the CFPB was so new, the director really hadn't done anything and likely wasn't going to do anything in the near future that gave anybody standing to challenge his appointment. Whereas the NLRB, much lower profile, issues orders every single day against private parties. So all you needed to do was wait for the newly constituted NLRB to issue a single order against a single company, and you instantly had a company that had standing to challenge that order. So we started following the docket, and on one day, the NLRB issued 3 orders against 3 companies. We called all 3 companies, and fortunately for us, the first one to call back was a company called the Noel Company. And so we sort of saw it as fate, and then we were off to the races with them, along with the Chamber of Commerce, challenging the recess appointments. But the larger point I'm trying to make is that I did find private practice to be every bit as interesting as what I had been doing previously.
Because you had the same high-level issues, and you were just able to transition that to private practice. And I assume that your client then was the Chamber of Commerce?
Well, not really. I would say the Chamber of Commerce was more in a co-counsel relationship with us because our client was the Noel Company.
Okay.
And so we and the Chamber appeared on behalf of the Noel Company. But yes, I think in another sense they were our client. They were the one that was paying the bill.
Right. So that, you did that, but you somehow got involved in a criminal case while you were there.
Yes.
So how'd that happen?
So this is the case of Virginia Governor Bob McDonnell, who was prosecuted for accepting bribes. And this is Hank Aspel, who's here today, was the lead trial lawyer in that case. This was a case, I think, that came to the firm more through Jones Day's managing partner, Steve Brogan, and the relationship that he had with Governor McDonnell, I think as a result of their joint work with Notre Dame University. But when it came in, Steve put together the team to handle it, where Hank was the lead trial lawyer and I was sort of the appellate person, which meant during the trial, Hank was the lead lawyer handling just about everything. I would help shape the motions, the jury instructions, argue the motions, argue the jury instructions, but Hank took the lead. When it moved to appeal, I then stepped forward and had more of a leading role on the appeals, first in the Fourth Circuit and then in the Supreme Court. We lost the case in the Fourth Circuit 3-0, but then we won it in the Supreme Court 9-0. It was a fascinating case because it really did go to the scope of the federal government's authority under somewhat vague federal criminal laws. There, was the bribery statute that prohibited a public official from engaging in a quote-unquote official act in exchange for receiving some kind of money. And the question was, did Governor McDonnell engage in official action? Our position was that what he agreed to do was set up meetings so that the alleged briber could make his case to the relevant government officials, but he never tried to put his thumb on the scale of the outcome of those meetings. What the Supreme Court said was that the jury wasn't properly instructed on that issue. They were instructed in a way that would have allowed Governor McDonnell to be acquitted, even if our view of the facts was correct. And so it reversed the conviction, sent it back to the lower courts, and the government decided not to try to re-prosecute him after that.
I don't know about you, but that decision really surprised me. I mean, he was getting bribes, $175,000 in bribes from somebody that he was essentially lobbying for in some respect. He'd hold meetings with his cabinet people. Were you kind of surprised?
Well, I'm going to let Hank argue with you about the facts, because I think he might disagree with your version of the facts. But I tell you, I knew from the beginning, and I think our whole team knew from the beginning, that the key would be preserving our legal argument and getting the Supreme Court to take it. But I was fairly confident that if we were able to preserve our legal argument cleanly and get the Supreme Court to take it, that we would win that case. That's the thing with Supreme Court litigation. There are lots of cases where if you ever get the court to take the case, you're going to win. But the Supreme Court only takes a very small percentage of cases. So the hard part is getting them to take the case in the first place. And so we focused very hard, both at the right from the get-go, including during the trial, at making sure we preserved the issue that went to the Supreme Court pristinely, and we raised it repeatedly to the point where, at one point, I think the district court judge chided us for filing something. I think he put it as, the 40th motion raising the exact same issue, and he's already rejected it 40 times, and now he was going to reject it again. But our main point was that we thought that the entire prosecution really did turn on that one issue, and so.
And you were right.
Yeah, and we ended up being right.
And so you would agree that it's really important when you're trying a case to hire an appellate lawyer to help you ferret out those legal issues so you can preserve them, right? And be able to raise them.
Well, look, I think that there's certainly, it obviously depends on the nature of the case, but there's certainly, I've always thought in my career in private practice that there was an important role that an appellate lawyer could play even in the trial courts. When I was at Jones Day, most of my cases were at the trial court level, arguing before district courts. Now, I wasn't the one putting on the witnesses, and I wasn't the one standing before the jury, but I was the one that was arguing a series of dispositive motions at the beginning of a case, trying to either get rid of it in the first place or narrow its contours before we went to trial.
So is at this point you started perceiving, or am I right or wrong, yourself as an appellate lawyer?
I don't think I ever really perceived myself as an appellate lawyer until I got the job in the Solicitor General's office.
I perceived you as an appellate lawyer.
Because I really did. The first set of cases that I cut my teeth on at Jones Day was a set of cases for R.J. Reynolds Tobacco Company, where they had allegedly violated the master settlement agreement between the states and the tobacco companies. And the way the master settlement agreement works is it's individually enforceable in every state. So Reynolds was sued by 15 states for the exact same thing, but there were 15 cases in 15 state trial courts. And so I spent about a year of my life flying around to different states and appearing in their state trial courts. And there's a really wide variety of practices. You show up in Chicago, and it's a pretty formal proceeding. You show up in Maine, and the first guy up there is pleading guilty to drunken disorderly conduct, and then you're up after him on behalf of R.J. Reynolds Tobacco, where it's a very informal proceeding. You kind of walk up to the bar and you're chatting with the judge and the opposing counsel. And I found that variety of practice, where you're in all of these different state trial courts, federal trial courts across the country, different personalities, to be fascinating. And I really do miss that part of the practice.
Well, we'll get back later on to going around the circuits. But so you're at Jones Day and you get a knock on your door. The opportunity knocks again with the government, and you're asked, he calls you up. Donald Trump calls you up and says, will you be my Solicitor General? Do you know him?
It doesn't quite work out that way. So take a step back. In terms of getting my current job, the most important decision I ever made in my career was when I was serving as the head of the government regulation practice at Jones Day. I think it was probably around 2015 or so. Another law firm in town was entering into a merger. Two law firms were merging. And one of the merging law firms had a election law practice group. And I was very good friends with the head of that election law practice group, mainly dating back to the Florida recount litigation where we had worked together. And he reached out to me to see if we were interested in talking to them, because given the merger, they were looking at potentially moving to a different firm. And at Jones Day, we weren't at the time really necessarily looking to get into the election law world, But this was the best Republican side election law practice in the country. And my understanding is election law practices tend to be either Republican side or Democratic side. You don't typically have major election law practices that cover both sides. And so when we had what appeared to be, the best Republican side practice in the country, we decided to take a look and kick the tires. And we ended up bringing this small group of lawyers in. One of those lawyers was a man named Don McGahn. Mm-hmm. Don McGahn went on to be the next counsel to the president after President Trump was elected. So after President Trump was elected, we all, by virtue of Don being our partner, we had some insight into the different types of positions and how to get different types of positions within the government. So that at least helped get me onto the short list of candidates for Solicitor General. I had never met President Trump until after I became, actually I went in as Deputy Solicitor General. I met President Trump for the first time when I was actually functioning as the Deputy Solicitor General. So as Deputy Solicitor General, I was the acting Solicitor General, and then shortly thereafter, I was selected to be the nominee to be Solicitor General.
A lot of people have left Jones Day, right, for the White House. And shout out to the Jones Day partners of yours who are here in the audience, who were at the meeting. So that was through Don McGahn.
I think that because Don was our partner, and so when we were representing the Trump campaign at Jones Day, because Don was representing the Trump campaign at Jones Day, that gave a lot of, Jones Day's a big law firm, but it gave a fair number of Jones Day partners who wanted to do that type of work exposure to the campaign. And we had a lot of very, very good young lawyers who were in DC and elsewhere who were interested in making a move into the government. And when you have that kind of exposure to a campaign during an election, and this case also generated a fair amount of post-election litigation. You had lawyers who had exposure to it by virtue of working on the post-election litigation. It gave them opportunities to see what was available in the government and it helped them make connections that allowed them to move into the government. So yeah, there was a good number of Jones Day lawyers, I think about a dozen or so, that went into the Trump administration at the beginning. Bear in mind, that's a relatively small percentage of overall lawyers at Jones Day, but in the early days,
that's only because it's a huge firm.
Yes, but in the early days, there was a fairly large number of Jones Day lawyers, principally at the Department of Justice and in the White House counsel's office.
So here you are, the Solicitor General. How do you like the job?
I love the job. I love the job. You are thrust into the most important and consequential issues of the day. One of the biggest things I had to learn is, when you're in private practice, even if you're a partner and even if you're a fairly well-regarded partner, you're still not always the ultimate decision maker. Mm-hmm. As Solicitor General, for the vast majority of what I work on, I often am the ultimate decision maker. And it took some adjustment to coming into that role. I still remember the first meeting that I went to. There were all these people from all these different agencies sitting around the table, and the conversation started, and I pretty much started out by saying what I thought. And what I learned was that had the effect of shutting down the debate, because everybody would think, all right, the decision's made, so what's the point? Or, if the decision's made, I don't want to appear to be contradicting it. Mm-hmm. And that's not a good way to make decisions, because you deprive yourself the benefit of the views of a lot of really smart people who really understand the issue better than you do. And I remember walking out of that meeting saying, I can't do that. I can't make decisions if I'm taking actions that prevent people from giving me the information that I need. So what I had to learn to do is now when I go into meetings, I'll try not to say anything for maybe a half an hour. And then I'll try to ask questions without stating what my position is, but I really did have to learn how to engage in that better kind of information gathering, because you really do have a wealth of information from people who have devoted their careers to representing the public interest and on issues where they really do have a lot to say. And if you don't get the benefit of that in your decision-making process, you're not going to be making good decisions.
Well, so you have all these people coming in and they're giving you this is how it goes, this is how it works in the government, this is what we think we ought to do from our experience. But then what about the White House's position on things? How does that factor into, is that like one of the people who are in the room during the decision? Or?
I mean, it really depends on the nature of the issue. I often get the question, who is your client when you're the Solicitor General? And at the end of the day, your client's the American people, but more specifically, it depends on the nature of the case. If we're fighting over the legality of a Environmental Protection Agency regulation, we will typically look to the EPA as our client agency, and we'll try to understand what their interests are, what their goals are, whether we can reasonably defend what it is they want us to do, and how we can advance our arguments in a way that both reflects our obligations as lawyers to be candid with the court, but advances their interests in whatever their policy agenda is. Not a whole lot different than what we try to do as lawyers in private practice. Now, if it's the president's executive order that's being challenged, then of course the White House is going to be the agency that the White House counsel's office really is going to be the agency that we look to as the principal client agency. So within that context, sometimes the White House is involved in our decision-making process because it's an issue that directly implicates White House equities, but most of the time, the cases that we're handling are representing different agencies throughout the government, and we're going to be looking to those agencies as the principal client agencies.
So when you have a statute and you're deciding, okay, here's a statute, somebody's raised a problem with the statute, I would think that normally you would go, okay, the presumption is going to be that's a valid statute, we're going to see if we can support it. So is that same holds true when you have an executive order where it doesn't have Congress behind it?
Yeah, more or less. Our general rule when it comes to defending acts of Congress is that we will defend the constitutionality of an act of Congress when a reasonable argument can be made in its defense. So it's not whether we ultimately think it's constitutional or unconstitutional, or whether we think it's good policy or bad policy. It's whether we think a reasonable argument can be made in its defense. That's essentially the same when it comes to regulations, executive orders, and other types of executive action. Can a reasonable argument be made in its defense? Executive orders tend to be fairly easy because as I mentioned earlier, whenever an executive order, before it gets signed, the Office of Legal Counsel has to approve it for form and legality. And it would be a rare case where OLC approved an executive order as legal, and then we in the Solicitor General's office would say, notwithstanding your approval of it for legality, we do not think a reasonable argument can be made in its defense.
But it did happen. I guess that did happen. But in the beginning of the Trump administration, I think.
Oh, you're talking about when
Department
then
didn't
acting
support.
Attorney General Yates declined to defend the travel executive order. That was a decision she made. Afterwards, we did then continue to defend the president's executive order in the travel area, and we ultimately won that case in the Supreme Court. So I think it validated our position that at the very least, a reasonable argument could be made.
And that's the case that you argued, am I
Yes.
right about that? Right, so
Yeah.
that's probably why you won, right?
Yes.
Right. 'Cause you-
No, we won because of this. The law was on our side.
That too. So what are the hats that you wear? I know there are many different ones. I'm not sure we all know all
Sure.
of the things that you do or are responsible for as the SG.
So the most public-facing thing the Solicitor General's office does is that whenever the United States appears before the Supreme Court, it's always represented by a member of the Solicitor General's office. So that's either me, one of my 4 deputies, or one of our 16 assistants to the Solicitor General. That group of lawyers represents the United States always before the Supreme Court, unless either the Attorney General or occasionally the Deputy Attorney General wants to argue a case, and then of course we will allow the Attorney General or Deputy Attorney General to argue a case. I occasionally get questions from the Assistant Attorneys General and occasionally from some of the U.S. attorneys asking if they can also argue a case, and they sometimes do. But the problem is the Supreme Court only hears argument in 75 or 80 cases a year. We participate in about 50 of those. And if you start handing out a lot of cases to other people, then the folks in the SG's office don't have the opportunity to argue. And one of the reasons we're able to recruit the amazing talent we have into our office is because we hold out the prospect of Supreme Court arguments. And if we don't have that to hold out to them, I think it would, in the long term, be detrimental to the office because we wouldn't be able to recruit the type of talent that we get now. So that's the most public-facing thing we do. We represent the United States for the Supreme Court. But that's not all that we do. Probably what takes the most of my time is, and this deals directly with the U.S. attorney community, anytime the United States takes an appeal. So we took a loss in the district court and we want to appeal that to the Court of Appeals or then ultimately to the Supreme Court. Anytime the United States takes an appeal, that has to be approved by the Solicitor General's office. Both the fact of an appeal and the substance of the appeal has to be approved by the Solicitor General's office. The purpose of that is to attempt to maintain some type of uniformity in litigation positions across the United States. You don't want to send somebody to jail in California for something that in New York we don't regard as a crime. There's kind of a fundamental unfairness to that. So we try to have this rough check to make sure that the positions across the country are being taken consistently. And it's also it's sort of a gut check to make sure that the positions that we're taking are defensible. That is rarely a problem, but it's occasionally a problem. And the reason why we know it's occasionally a problem is because you can look at the types of cases that don't come through our office for approval and eventually make their way to the Supreme Court. So there are a handful of cases where we win at trial court, we successfully defend in the Court of Appeals, and then take, for example, the criminal defendant seeks certiorari in the United States Supreme Court. In that posture, the first time my office will actually see the case is when it's before the Supreme Court, and then you're in the position of either defending a win in the Court of Appeals or confessing error in the Supreme Court after having won in two courts, and that's not something that you do very lightly. This happens almost never. But in the handful of cases over the last dozen years or so where it has happened, it's been principally in the white-collar area, where cases, it's kind of like the McDonnell case. The government won in the trial court, won in the Court of Appeals. First time it got to the Supreme Court, first time the SG's office was directly involved was when it got to the Supreme Court. Supreme Court reverses 9-0. Another good example of that is a case called Bond against the United States. I don't know if anybody's familiar with this case, but this was from maybe 7 or 8 years ago. A woman in Colorado had a dispute with her neighbor and erstwhile best friend who she believed was having an affair with her husband. So she went to the hardware store, bought a bunch of household chemicals, put them on her neighbor's doorknob and mailbox. Neighbor comes home, touches the doorknob and mailbox and gets some burns on her hands, which she treats, according to the Supreme Court's opinion, by running her hands under cold water. State prosecutors didn't think this was worth their time, and enterprising AUSA in Colorado disagreed. And so he prosecuted this woman for violating the statute that implements the Chemical Weapons Treaty. So essentially charged her with violating the Chemical Weapons Treaty. One in the district court, one in the Court of Appeals, gets up to the Supreme Court and loses 9-0. Now, in general, this is not that big of a deal. We lose cases. You win some, you lose some. But the problem is that cases like that do two things. And over the last dozen years or so, and I've talked about this with the U.S. attorneys a lot, and they're very attuned to this issue. Over the last dozen years or so, we have lost a fairly substantial number of white-collar cases in the Supreme Court by lopsided 9-0 margins. And it's something that was important to my predecessor, Don Verrilli, to try to address because he found it troubling. And it's something that's important to us now to try to address as well. And so we're trying to take steps to prevent that from happening. But it does two things. First, you take a little bit of a hit to your credibility in the Supreme Court, because you're going up there with positions that seem pretty far-fetched. And so typically when we go to the court, we like there to be a presumption that our positions are at least, very well grounded. And in cases like this, you take a little bit of a hit to that. I think the more important thing, though, is a lot of times these cases implicate principles that go well beyond the facts of that case. Take this case, Bond against the United States. It was a pretty nothing burger case from the facts. But in this Supreme Court decision, I want to say 3 justices voted to reverse the conviction because they thought that another doctrine, a doctrine called Missouri against Holland, ought to be overruled. Now, Missouri against Holland is a doctrine that is very controversial, but it's very important to the State Department when it comes to negotiating treaties. So we put into play, in this case, a legal doctrine that was extremely important to the State Department in the foreign affairs context on a factual case that really probably never should have been brought.
It should never have been brought, so it never would have come up.
Yeah.
So what do you think that you'd address that problem by agreeing to certain cases you otherwise wouldn't, just because you think that's going to be a better case than something else that's going to come down the pike?
I think the better way to address it, and which is the way we are addressing it, is by when we collaboratively with the U.S. Attorney community are attuned to this issue. And so I think that they're very focused in their charging decisions on making sure that when we charge a case, we are well grounded within the text of the statute and we're not pushing the bounds of federal criminal statutes.
And how
because
do
it's
you
when
do
you
that?
push those bounds, well, look, it comes down to judgment. And I think if people are sensitive to the issue and people have good judgment, and I think that we have U.S. attorneys that are sensitive to the issue and U.S. attorneys that have good judgment, you're not going to be making prosecutorial decisions that raise these issues down the road. So part of it is thinking ahead. What are the implications of this case that we're bringing? Look, sometimes you bring an aggressive prosecution and it's not a big deal because it's not raising larger issues. And from my perspective, I'm fine with aggressive prosecutions that aren't raising issues that we're not really thinking about. What really bothers me is if we bring an aggressive prosecution that implicates another doctrine and it implicates that doctrine we hadn't even thought about it. So there wasn't really a considered decision made. I'm quite confident that we're not doing that now because I think our folks are very focused on this and making sure that they're not doing it. But it does, there are a lot of cases that are being brought and sometimes things fall through the cracks. The best you can do is focus on it and try to address the problem.
And so there's a communication with the U.S. Attorney's office's positions being told, because I love that. When I was appellate chief, I wanted to hear that. We are, I like to think that we have a very good collaborative relationship with the U.S. Attorney's offices. I try, and I'm not as good as I wanted to be, but I try to get around to as many offices as I can to meet with the offices and the AUSAs and the offices. I think these guys know that if there's ever an issue, if you ever think my office is heading in the wrong direction, my door is open. I've had many meetings with U.S. attorneys where there was initial disagreement on a certain direction, and we'd get together and talk about it and hopefully come to a consensus on the best way to proceed. But I think that if the Solicitor General's office is viewed as this ivory tower in Washington that just looks at the papers and makes a decision, yes or no, that's not a very effective way to run the government. That is kind of viewed as ivory tower.
It may be, but I am hopeful that we're taking steps to prevent that.
Well, taking calls from U.S. Attorney's offices is one thing. When I was in the U.S. Attorney's office, calls would come in to the prosecutor and they'd try to work out something they disagreed with, and they go up the food chain to the criminal chief or then to the U.S. Attorney, and often the U.S. Attorney would take the call. Do you get those kind of calls where you're taking a position on an issue and either the public or a party wants to go up and talk to you?
Oh, most definitely. I'll give you an example. When the Supreme Court often, when somebody files a cert petition, that potentially implicates federal government equities. The Supreme Court will do what's called Call for the Views of the Solicitor General, or CVSG, where they invite us to file a brief saying whether or not the court should take the case. Our standard practice when that happens is we invite both sides to come in separately and to make the case to us why, in their view, we should either side with them or stay out of the case. And so it's quite common for us to meet, particularly when we're participating as an amicus as opposed to a party. Mm-hmm. It is quite common for us to meet with the parties, typically both parties, to understand, to get their views to help us formulate what our own position is going to be. It doesn't happen as much when we're a party because, our position's locked in, their position's locked in, and we're going to just have our dispute and have the courts resolve it. But when we're coming in as, somewhat of a neutral third party, as an amicus, then it is important to hear the actual party's views to make sure we're formulating the right position.
Can you explain a little about the setup of your office, the hierarchy?
Yeah. So there's the Solicitor General. There are 4 deputies to the Solicitor General, one of whom is the principal deputy. And the only 2 political appointees in the office are the Solicitor General and the principal deputy Solicitor General. The 3 career deputies generally cover certain subject matters. You have Malcolm Stewart, who covers what we call the business docket, antitrust, SEC enforcement, things that you would often see private practitioners engaging in. Ed Needler, who is our most senior deputy and has argued, I think, 135 cases now, just celebrated his 40th year in the office. He handles a lot of the immigration cases and a lot of the challenges to federal government programs. Previously, the criminal deputy was a man named Michael Dreeben. Michael recently left, and so we're in the process of replacing him. But during his absence, and for most of my 2 years actually, that role has been fulfilled by one of my assistants named Eric Fagan, who oversees the criminal docket. Beneath the deputies, you have 6 assistants to the Solicitor General, and they don't have specific dockets. So they're generalists that have to handle just about anything that comes in. The way we assign oral arguments is strictly on the basis of seniority. So our most senior, the deputies will all argue probably 5 or so cases a year. Amongst the assistants, the more senior assistants will argue 3 cases a term. Middle ones will argue 2 cases, and the new ones will argue 1 case a term. And then beneath them, we have 4 Bristow Fellows. Bristow Fellows they've graduated from law school. They've typically had a very prestigious appellate court clerkship, and they come to us for 1 year, and they essentially function as associates within the office. That's pretty much the office, but we couldn't do everything that we do unless we worked really closely with and had a lot of help from all the lawyers throughout the rest of the government. So I talked about how I have to approve every appeal that the government takes. Well, it's not like somebody just tells me, oh, they want to appeal this case, and I then read all the briefs and read all the decisions to decide whether or not to appeal. Take a criminal case. First, the U.S. Attorney's Office is going to send a memo recommending whether or not to appeal. That'll then go to the criminal division. The criminal division will review it and write another memo saying whether or not they concur with the U.S. Attorney's Office. That'll then come to one of my assistants who will review it and give their position on whether or not they concur, and then it'll go to a deputy. So I'll have essentially 4 layers of review before it lands on my desk. One of the first things I do is I look at it, do the recommendations line up? If everybody is in agreement, then I'll take a look through the packet fairly quickly to make sure I agree. If there's disagreement, that's when I feel like I really need to dive in, because if I'm going to have to, if really good lawyers looking at the same issue have come to a disagreement, it's really important for me to understand why and to make sure that we're doing what I think is the best going forward.
And those are the appeals from U.S. attorneys' offices when they have an adverse decision.
Yes.
Down in the U.S. Attorney's Office, and they decide they have to affirmatively, in those circumstances, affirmatively say, I want to appeal and write something up.
Yep.
How much are y'all watching and saying, I don't like what's going on there, and you're telling them you need to do something about that, or do you even have
in the middle of a
time?
trial?
No, like after a trial's,
Oh, after the trial's over?
you're taking a position,
You know,
you're going to get one of these bad cases.
I'm not going to say that.
Would you even know?
I'm not going to say that never happens, because occasionally but I can't think of something like that during my tenure, because there are just too many trials. We don't, the U.S. attorneys are appointed because the president trusts them and has delegated an enormous amount of authority to them. It's not my role. I certainly don't view it as my role to look over their shoulder and make sure they're doing their jobs right. They're given that position because the president trusts them to do their jobs right. And so I assume that too. So I pretty much try to stay in my lane. And when things come up to me, then I make a decision based on what's before me.
Now, all the work you've got to do as SG, that probably doesn't leave tons of time. How do you decide if you want to argue a case, and what enters into that decision?
Sure. So the Solicitor General, the Supreme Court hears arguments from starting in October, ending in April. And they typically hear arguments for 2 weeks each month. The Solicitor General will typically argue one case every month. Maybe take a case 1 month off over time. So that means you're arguing either 6 or 7 cases, maybe 8 cases in a busy year. So each month I sort of look what's on it, and sometimes it's obvious which case the SG has to argue. Typically, the SG is going to argue the cases that are the most consequential to the government or to the administration, or frankly just the most important issues. If there's not something like that, then I'll kind of look at the cases and just try to pick one that I find to be the most interesting. So when the court granted on the president's travel executive order back in the beginning of the administration, it was pretty obvious that I had to argue that case. The census case, whether the government could include a citizenship question on the census, that's obviously that's an obvious case for the Solicitor General to argue. In October, the October and November calendars have been set. So in October, I'm going to be arguing 2 related cases about whether Title VII covers sexual orientation and gender identity. And in November, I'm going to be arguing the case about whether the government can lawfully rescind the DACA program. That's the program that gives certain status to illegal aliens who came here as very young children. So, again, when you looked at the dockets, it was pretty obvious that those were the cases that I'd have to argue. I frankly prefer the months where there aren't cases like that, and I can pick one that I find interesting, but isn't necessarily one that's going to be, splashed on the front pages
like
of
Travelgate?
every paper.
Would you have wanted to argue the Travelgate?
I'm actually recused from the Travelgate
You're recused
case,
from
the
Travelgate.
Bridgegate case.
Right.
Yeah, but it is an interesting case, and it's, I think, one amongst the many factors that went into our ethics officials' views was its similarity to the McDonnell case, and so I think it may well raise similar issues in the Supreme Court.
Well, we wanted to leave a lot of time for y'all for Q&A, so I hope y'all been thinking about some questions. I've certainly had a bunch of questions, so if y'all have any questions for General Francisco.
BJ.
So Solicitor General, what is one or two of the Supreme Court advocacy traditions that general practitioners may not be aware of that you found to be very interesting?
So the question is, what are some of the traditions in the Supreme Court that everybody may not be aware of, but that are interesting? One of them is that when you step up to the podium, a lot of us who practice in lower courts, you step up to the podium and Noel Francisco on behalf of so-and-so. You do not do that in the Supreme Court. You step up to the Supreme Court and the opening line is always, Mr. Chief Justice, and may it please the court, and then you just launch straight into your argument. So that's one that, and because that's different from most, when you step up to the podium, there's actually a card on the podium that says, this is how you should open it. And it also specifically instructs you, you don't refer to the Chief Justice as Chief Justice Roberts or Justice Roberts, it is Mr. Chief Justice. So that's one interesting tidbit. The other that I wish they would change is that there's no clock on the podium, so you don't really know how much time there is, except for this sort of red light, yellow light system. There is a clock that sits immediately above the bench, but you're told that you're not supposed to look up at that clock, nor are you supposed to look at your watch. So you really don't have a real good sense for how much time is going by. What I have done is I have this practice where for a 30-minute argument, I always want to save about 5 minutes for rebuttal. And I don't always notice when the little yellow light comes on in front of me. So I always have my assistant just take a big red index card, and when I have about 6 minutes left in my argument time, the assistant just sets the red index card on the podium in front of me. So that way I know, all right, I got to wrap things up if I want to have some rebuttal time. One of the frustrating things, though, is when you're thinking about trying to save a good 5 minutes for rebuttal, and as you hit that 5-minute mark and you start to try to sit down, one of the justices interjects with a very long-winded question and pretty much eats up all of your rebuttal time. The Chief Justice is pretty good when that happens, of giving you another minute or two on your rebuttal, but not always. So,
Are you pretty happy about the outfit you get to wear? They look great.
oh yeah, I guess that's the other tradition is that in the Solicitor General's office, all men in the office have to wear morning suits, and women have the option of wearing morning suits if they want to, or a modified version of a morning suit if they want to. So you're wearing, the tuxedo with tails and a big tie and vest, so you stand out a little bit in the courtroom.
You don't have to worry about what you're going to wear.
No,
They always
you
look
always
good.
know what you're going to wear.
They always look good.
Yeah.
Yes.
Just to follow up on that, just so the Solicitor General knows the effect you're having on the next generation of legal minds. My son's at Georgetown Law, and I told him you were speaking, and he said, well, we see him on campus occasionally, and his suit game is strong.
I'll leave that one at that.
Any other questions? Yes.
Yeah.
Talk a little bit about the process that your office undertakes and how you prepare for Supreme Court arguments?
Sure. And the question is, how do we prepare for Supreme Court arguments? And every lawyer has their own style of preparation. Everyone at the end, it's the same for everybody. We do 2 moot courts for every case, no matter how important or not important. The week before argument, you'll have 2 moot courts that are attended by, we'll assign 3 assistants in the office to play the role of justices. And then there will be other lawyers from other agencies and throughout the department that have an interest that attend as well, and they can also ask questions. But you do 2 2-hour moot courts. For me, at least, that's the very end of my preparation. I like to be essentially ready to go by the time the moot courts happen. And then I use the moot courts as ways to test out different answers. So I might know I'm going to get this line of questions, and I might have 2 different potential answers, and I want to try them both out to see how they sound. The real prep for me comes before that. And that is, this is one of the first jobs I've been in where I'm often arguing cases where I wasn't the lead person writing the briefs. I didn't handle the cases in the courts below. So you're really coming to it relatively cold in a lot of the cases with a set of briefs that somebody else was the principal draftsperson on. So I go through a fairly lengthy and detailed process of reading the briefs, reading the amicus briefs, reading the record, trying to get everything in my head. And once I do that, I'll just sit down with a piece of paper and say, all right, now that I've read everything, if I just had to stand up there for 30 minutes without any questions, what would I say? And I just try to jot out a basic outline. And from that, I develop probably 8 or 9 or 10 key points. And that's what I bring up to the podium with me. I'll have 2 pages with 10 key points. And if I've done my preparation correctly, the answer to any question I get will be one of those points on the paper. Because usually a case in a 30-minute argument, a case is going to boil down to no more than 10 points and probably significantly less than that. Often you end up making 3 or 4 of them. But at the end of the argument, I look and I actually ask myself, did I have to answer any questions I didn't anticipate on this? And if I did, if I did, that's kind of how I judge an argument that didn't go so well, because I hadn't anticipated it well enough. But if I was constantly referring to that page for the answers, I felt like it went well, that I was saying the things that I wanted to say, the points that I think affirmatively advance my case.
Do you ever see when cert is granted on a case, you see it pretty early and you say, I'd like to get involved in the briefing of that? I mean, do you have time? Do you? Yeah,
yes, and like, look, on the case, there are several cases that I argue where we're involved early on in the case because we know from the get-go it's going to the Supreme Court. Travel executive order. We were involved I was reviewing district court briefs in that case when I first started in the job. The census case we knew was going to end up in the Supreme Court, so I was very attuned to what was going on in the lower courts. And cases where I know I'm going to argue it because of the nature of the issue, I'll take a larger role in writing the briefs, partly because I know it's going to help me on the preparation at the back end, since I will have already gone through the drill of really understanding the issues. So yes, I'll often get more involved in cases I know I'm going to be arguing at the front end of the briefing.
What cases do you see coming up this term that you think are particularly interesting that we should watch for?
Sure.
In addition to the ones you're
Yeah.
going to be arguing, which of course we're going to be watching.
I think this is shaping up to be one of the more consequential Supreme Court terms in recent years. But I don't think it's primarily because of the criminal cases. I think that the Title VII cases are going to be extraordinarily consequential. The DACA case is a very important one. And those two, if you have those 2 cases in any Supreme Court term, that's enough to make a banner Supreme Court term. But there are a bunch of other interesting cases, including in the criminal area. I think that the Bridgegate case is the most important one from this group's perspective. I mentioned that I'm recused from that, so I'm not arguing it. I don't know it as well as I ordinarily would because of that. But in a nutshell, it involves some staff members to then New Jersey Governor Chris Christie, who apparently shut down several lanes of the George Washington Bridge that led into Fort Lee, New Jersey, in order to punish the mayor of Fort Lee, New Jersey, for refusing to endorse Governor Christie in his reelection. And so they have been, the defendant in this case was convicted of fraud under the federal fraud statutes, and the basic theory is that she deprived the Port Authority, a governmental entity, of money and property through fraudulent pretenses by getting them to devote labor, employees, to shutting down the Port Authority under false pretenses.
When they claimed it was that they needed to do it.
Some kind of traffic study, I think.
Yeah, and they really didn't. They just wanted to, retribution on the mayor?
Retribution on the mayor. And so the Supreme Court has taken that case. I can't remember when it's going to be argued, but it'll be interesting because I think this is one of the bigger cases they'll have taken in the area of white-collar federal fraud statutes since the McDonnell case. I think another one that's kind of interesting and maybe has some relevance to you all and also implicates when the United States confesses error is a case that has to do with when you have to object to a sentence. In this case, the defendant proposed a particular sentence that was much shorter than the sentence that the government proposed. And the district court adopted the government's sentence. So the question is, does the defendant have to object again to the longer sentence after he's already requested and lost on the lower sentence? And it has to do with whether you do plain error review or not plain error review on appeal. Now, the government actually argued that the defendant had waived his challenge to the sentence by not raising the objection again. But when it got to us in the Supreme Court, we looked at it and just said, just when you look at the plain text of the federal rules, it doesn't make sense. So we've actually, it's a case where we've confessed error, and we've said that the defendant should not have been subjected to plain error. By requesting a shorter sentence, you necessarily put both the court and the parties on notice that you disagreed with the longer sentence. It seems pretty obvious. And so it should be subject to the standard review, not plain
We'd like to
error.
commend you for confessing
Yeah.
error on that, because
And
you're
look,
right.
it happens a couple times, but it's usually pretty clear, cases where we pretty clearly think that we got it wrong. And that's one of the great things about the government, is that you have the ability to do that when you really do think that you got it wrong.
Because you want to do the right thing.
Yeah, yeah.
We have a question over here.
Yes.
What are your views on how the media covers the work of the court and the work of your office? And is there any commentary you find particularly helpful or anything really frustrating?
Uh-huh. So the question is, how do I feel about the media coverage of our office? And I guess I'll break it into two categories of media coverage. The media that principally covers the Department of Justice and the Supreme Court, and what I'll call, as part of their beat, regular reporters, and then the opinion columnists. I find that the regular reporters that cover the Supreme Court are excellent. I think that they have a firm understanding of the cases, they understand the arguments, and for the most part, I think that they fairly represent our positions, both in our briefs and at the arguments, and they understand them. When I get frustrated, it is almost never with what I would consider the standard reporting, but rather with the commentary. But I think that's just something that you have to get used to as a government official, because the commentary, often the goal of a commentator is not to accurately describe what happened, but rather to state an opinion or to push a position. And when people are engaging in that type of journalism, I think they take greater liberties with what happened or what was argued, and they often engage in caricature. And that part of the coverage is where I find the most frustration. So I try not to read as much of that and focus on the main reporting.
Do you find the commentators sometimes get the facts wrong, which cause their whole comment to be skewed, and you
Yeah.
feel like you want to call them up and go, no, that's not it?
Yes on the first part. No, I never
No.
feel like there would be any value to me calling them up.
Yeah.
Yeah.
Are we ever going to have cameras in the courtroom in federal courthouses generally or at the Supreme Court?
I certainly hope not. So in the Supreme Court, I'm quite confident we're not going to have cameras in the courtroom during the course of at least my professional career. I don't think that there's a single justice who is in favor of cameras in the Supreme Court, and I know that the Chief Justice is firmly opposed to cameras in the Supreme Court. I guess if you'd asked me this question 20 years ago, I might have had a different position. But now, with the age of the internet and social media and the way that clips can be taken out of context, I worry that if you have cameras in the courtroom, you're going to have lawyers and potentially justices that are not so much focused on the merits of the case and figuring out the right answer is, but focused on, how what they say is going to play in the media. The Chief Justice has used an example of where, say a lawyer's up there for a company, he's got to think less about what the right legal answer is to a question and more about, how is this going to impact what I say impact the company's stock price. I've also seen in recent times, we had a very fine career attorney who was appearing out in the Court of Appeals in California on an immigration case, representing a long-standing government position on a controversial issue. And she made perfectly legitimate statements in response to a question that were taken out of context, went viral on the media, and as a result, she was subject to some very significant harassment at her home. And I just worry that when you have that kind of camera coverage, when you combine that with the social media age, that we're in, and to a certain extent, the political environment that we're in, it's just not worth the candle.
Are there any other? There's,
Yeah. Oh.
Oh, I'm sorry.
Georgia has over 700,000 veterans. Has there been any increase in appeals in your office handling veterans appeals?
So the question is, has there been an increase in the number of veterans appeals that we've handled? You know, because there's such a small number of cases that actually come through my office in the Supreme Court, I don't know the answer to that, but it's also not that meaningful because it's just we're in a certain sense a reactive office. Does a case rise up the Supreme Court, the level of Supreme Court review? But what I can say is that there have been some very significant cases that involve veterans appeals that we've argued. I argued a case last term called Kaiser against Wilkie. Now, the legal issue at stake didn't have anything to do with veterans appeals. It had to do with whether the Supreme Court should overturn something called Seminole Rock deference. That is, if an agency has a regulation and the regulation is ambiguous, you defer to the agency's interpretation of their own regulation. But it did arise specifically in the context of veterans appeals, and the question was the Veteran Board of Appeals interpretation of their ambiguous regulations entitled to deference? That was an extremely important administrative law case that the Supreme Court took in the context of veterans appeals. And because the veterans appeals process is such a complex administrative process, it does give rise to a large number of important Administrative Procedure Act type of cases. And so I think when I see veterans appeals cases in my office, they tend to be in the context of Administrative Procedure Act type issues. Yes?
Solicitor General, how approachable are the Supreme Court justices outside of the court?
So the question is, how approachable are the Supreme Court justices outside of the court? I think every single one of them is extremely approachable. If you saw them at a function and you chatted with them, you would have a delightful and pleasant conversation. That said, they have to have, they by definition have to have limited social engagement because there are only 9 of them and they can't get everywhere, and they're often being besieged by lots of different people, and they also need to be protected because, again, there are only 9 of them. So I think every one of them is extremely social and extremely engaging, but I think that it's very difficult for any individual just to kind of walk up and get access to them. From my perspective, I know some of the justices better than I know the others. I see them occasionally at social engagements, but at the same time, I'm cognizant of the fact that I'm a repeat player before them, and so there has to be a certain amount of formality in our relationship, and I think that I try to maintain that kind of formality as well.
If there aren't any other questions, I would like to thank you so much for joining us and for being so open and answering all these questions. It was a pleasure. Thank you for being here.
Thank you.